Global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome to Global Happenings today. Nnamdi Kanu's legal team are firing on all arsenal. I don't know if it's cheaper right now to let Nnamdi Kanu go because the demands they're making, judging the fact that Nigeria as a country is borrowing so much. In fact, they have gone borrowing just to even fund their budgets. So you can imagine, maybe it's a bit cheaper as a country to let Nnamdi Kanu go. Before we go into the newspaper to find out how much they are making demands of and how they intend to get those monies out of the federal government of Nigeria, I'd like you to subscribe to our channel by clicking on the red subscribe button beside it. You will see the notification icon. Please go ahead, click on it to get notified as soon as we update our channel on YouTube. Well, as we speak, Nnamdi Kanu is actually standing trial on charges bordering on treasonable felony and terrorism before a federal court in Abuja, where the leader of the indigenous people of Biafra, Nnamdi Kanu, has asked the Federal High Court in Abia State to award him 25 billion. You heard me. 25B as in Biro, 25 billion naira as damages for the breach of his fundamental human rights by the Nigerian government. Kanu is being held by the Department of State Services, that's DSS, at its headquarters in Abuja after the Nigerian government repatriated him from Kenya in June 2021 and action his legal team and lawyers termed illegal, unlawful, unconstitutional extradition. He is standing trial on charges bordering on treasonable felony and terrorism before a federal high court in Abuja. In the new suit, Kanu's lawyer Aloy Ejimakor prayed the court to declare his arrest, his torture and detention as unconstitutional. He also prayed the court to declare that Kanu's expulsion from Kenya to Nigeria was illegal and unlawful. The relief sought include, and I quote, a declaration that the arrest of the applicant in Kenya by the respondents, their agents, without due process of law is arbitrary, and the respondent enforced disappearance of the applicant for 8 days and their refusal to produce the applicant before a Kenyan court for the purpose of applicant extradition is illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental right against arbitrary arrest to his personal liberty and to fair hearing as enshrined and guaranteed under the pertinent provision of CFRN and the Charter. 2. A declaration that the detention of the applicant in a non-official secret facility in Kenya and the torture of the applicant in Kenya by the respondent agent is illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental right against unlawful detention, torture, and to fair hearing as enshrined and guaranteed under the pertinent provisions of CFRN and the Charter. 3. A declaration that pursuant to Article 12, subsection 4 of the Charter, the expulsion or extraordinary rendition of the applicant from Kenya to Nigeria by the respondent without a decision taken in accordance with the law of Kenya is illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental right to fair hearing and not to be expelled from a state party to the Charter except by virtue of a decision taken in accordance with the law as enshrined and guaranteed under the pertinent provisions of CFRN and the Charter. 5. A declaration that any criminal prosecution of the applicant, the purpose of which the respondent unlawfully expelled the applicant from Kenya to Nigeria is illegal, unlawful, unconstitutional, and amount to infringement of applicant's fundamental right to fair hearing as enshrined and guaranteed under the pertinent provision of CFRN and the Charter. An order of injunction restraining and prohibiting the respondent from taking any further step in any criminal prosecution of the applicant enabled by the said unlawful expulsion of the applicant from Kenya to Nigeria, an order mandating and compelling the respondent to forthwith restitute or otherwise restore the applicant to his liberty, same being his state of being as of the 19th June 2021, and to thereupon repatriate the applicant to his country of lawful domicile, to which is the United Kingdom, to await the outcome of any formal request, and respondent may file before the competent authorities in Britain for the lawful extradition of applicant to Nigeria, an order mandating and compelling the respondent to issue an official letter of apology to the applicant for the infringement of his fundamental right, an application of said letter of apology in 3 national dailies. An order mandating and compelling the respondent to pay the sum of 25 billion naira money to the applicant, being monetary damages claimed by the applicant against the respondent jointly and severally for the physical, mental, emotional, psychological, property and other damages suffered by the applicant as a result of the infringement of applicant's fundamental right by the respondent. Also speaking, Barrister Ejimakor said, today being the 25th March of 2022, on behalf of Nnamdi Kanu, I am leading a team of lawyers at the first hearing of the fundamental right enforcement suit I had brought before the Umuahia Division of the Federal High Court. The matter lies before Justice Evelyn Anyadike. The suit is sui generis and primarily aimed at redressing the infamous unlawful expulsion or extraordinary rendition of Nnamdi Kanu, which is a clear violation of his fundamental right under Article 12, subsection 4 of the African Charter on Human and People's Rights. In addition to the rendition, I am asking the court to redress the myriad violations that came with the rendition, such as the torture, the unlawful detention, and the denial of the right to fair hearing required by law before anybody is expelled from one country to the other. You will recall that on the 19th January 2022, the High Court of Abia State determined that portion of violation of Kanu's fundamental rights that occurred in 2017, even as I had made claims that bordered on rendition, the court declined jurisdiction on grounds that rendition being related to extradition lies within the exclusive jurisdiction of the Federal High Court. So the instant suit is as a result of my considered decision that a fresh action before the Federal High Court will be the best route towards addressing this matter of rendition or unlawful expulsion and its legal impact on the prosecutionary powers of the Nigerian state. To be sure, the extraordinary rendition of Nnamdi Kanu has triggered legal injuries that cut across multiple jurisdictions both inside Nigeria and abroad. There are now new legal and even diplomatic issues that must be addressed in the United Kingdom, Kenya, United Nations, and African Union, and within Nigeria, the rendition has expanded the matter far beyond the realms of the trial that lies in Abuja. I would like to seize this opportunity to express my profound appreciation to a highly competent and professional team of lawyers that I'm leading in an aggressive prosecution of this complex suit. He gave special thanks to Barrister Patrick Agazie, Oheto, Nwazie, and Mandela. Alright, Nigerians have been reacting. Let's meet in our comment section. A lot of people have been talking. And remember, he won himself. He won for Nnamdi Kanu 1 billion naira, although the federal government is yet to pay or appeal at that case. But he won for Nnamdi Kanu 1 billion naira, and now he's asking for 25 billion naira.